Good afternoon, everyone. Thank you all for joining us. My name is Guy Temple. I'm an attorney with our litigation department here at Reinhardt Berner Van Duren. My colleagues, Christopher Sheely and Shannon Toole, will also be presenting with me today. Christopher and Shannon are both from our labor and employment departments here at Reinhardt. As many of you hopefully know, Reinhardt is a gold sponsor of the Wisconsin Veterans Chamber of Commerce. We've done a number of in-person events before the current times, as well as joining on the weekly member briefing a couple weeks ago. So some of you may have heard from us on this topic a little bit already, and we'll get into some more depth here today. I'm going to go ahead and get us started out here. And as we proceed, please utilize the the webinar functions to ask questions if you would like. Or if you have comments to the organizers or the presenters, I think you can include those in the chat function. Later, I think some of our presenters may have some polls, so feel free to answer those. It helps us get a little more background information on our audience. But please do ask questions. Feel free to pose those during the presentation. You don't need to wait until the end. We'll answer them as appropriate, but we're happy to have this be an open discussion, even though we're all separated here. So thank you, and we'll go ahead and get started. General disclaimer, obviously the information we're providing here is general. Additional facts and information may affect these subjects, and your particular circumstances may be different, and the information may affect your circumstances different. So you should consult with a lawyer before acting on any of this information, just to make sure it's applicable to you and your business. I'm going to start out talking a little bit about insurance coverage for COVID-19 losses and updating where we're at with that. And then we'll move on and talk a little bit about some of the commercial contracting challenges and concepts that we're dealing with as we manage supply chain disruptions for businesses here in Wisconsin and around the country. So beginning with insurance coverage, I'm sure many of you are familiar with these topics already or have been down this road, but we're going to give a kind of an overview of the types of coverage and then the situation that we're seeing. Business interruption coverage is the most commonly discussed one, and unfortunately the most commonly denied one as of right now. But in addition to that, there's civil authority coverage that may provide coverage for circumstances in which civil authorities have caused your business to be unusable, your operations unusable, and then also contingent business interruption, which applies where there is an interruption that is covered to someone in your supply chain. Maybe it's a supplier, a vendor, or maybe it's a customer that has interrupted your customer base, your market for a product or service. So beginning with business interruption coverage, generally this is going to be through your property policies and require physical damage to the insured property that is caused by a covered peril. This is the big question that businesses are dealing with and that insurers are generally denying coverage on, because the issue of physical damage doesn't apply to a lot of businesses, dealing with the coronavirus outbreak. Business interruption coverage may also cover damage to the business premises, other than the actual structure, or other equipment within the business. So various machinery, maybe it's vehicles that you're utilizing on your premises. But the physical loss or damage doesn't have to be confined to physical destruction. Fire, water damage, etc., is what we would commonly think of as structural damage to the property. But frequently, business interruption coverage provisions will include conditions that make the property unusable. So that's where there has been some argument on a lot of business interruption claims thus far, is whether or not the coronavirus falls into a contamination that renders the property unusable, whether there needs to be an actual detected incident or outbreak of coronavirus within a facility in order to be considered physical damage. So that's what business interruption coverage will generally include. Exclusions. Now, as we're seeing with a lot of these policies in which businesses are making claims, policies may have exclusions for pollutants, contaminants, bacteria, mold, pathogens, and the wording of those is really critical. Some of them have very broad contamination exclusions that insurers are arguing includes viruses. But on the other hand, where they call out specific items that are excluded and don't specifically cite viruses, like the COVID-19 virus, there may be arguments that that's not excluded and it's not included there. Often you see exclusions for bacterial contamination, but not necessarily specifically viruses. If there is coverage and there is a covered peril, and what constitutes physical damage or physical loss to the property, quantifiable losses due to the interruption are what is typically covered. So that's going to mean whatever you can show you are out of pocket as a result of that interruption, that is likely going to include your lost profits. How that is measured is a really critical question, and particularly in the current circumstances where the economy post-quarantine, post-lockdown is going to be a very different place than what it was prior to the outbreak of coronavirus. There is some question as to how that loss is measured. Is it measured based on the economic situation prior to the catastrophe or following the catastrophe? There's a couple of different lines of thought on that. As you're looking at the time period, some courts look at what's called an economy ignored approach. So they look backward and measure the business's loss only against the pre-catastrophe business levels. So, what was your business like? What was your volume? What were your production levels? Your sales levels? Profits and losses prior to the catastrophe, to avoid a scenario where you're getting a windfall because the economy has changed and your business would be substantially increased. On the other hand, some courts have an economy considered approach where they're looking to put the business in the position it would have occupied post-catastrophe if it had been able to continue its operations. The way this would play out, for example, if you think about a hotel or a restaurant, most of our hotels and restaurants in this city and across the state are now dealing with an economic situation in which there's very little demand. But in December, January, February, they may have been operating at very high levels. How a court is going to look at that, how an insurer considers that in assessing a claim, or a court perhaps if an insurer's denial or coverage is challenged, is going to depend on whether you're looking at the pre-catastrophe good business or whether you're looking now. On the other hand, if you're a restaurant or a diner or a hotel that's near a medical facility, and as a result of the coronavirus outbreak, you have had booming business, you're operating at full capacity, there's some question as whether or not you get your losses attributed to the current economy or prior to the catastrophe. If, for example, that hotel next to the hospital has an outbreak of its own and has to shut down, what position does the insured get put in? And again, that's a question that may depend on policy language and may depend on the jurisdiction that you're in. Your interruption coverage can extend for a period beyond the period required to repair the property damage. Typically, the time period you're looking at is what's necessary to restore or repair property. So the difficulty in our current circumstance with coronavirus is even if a business does have coverage for the outbreak, typically it's been restricted to an actual incident of contamination, meaning the business is shut down for 48, 72, 96 hours in order to get a crew in and completely decontaminate, deep clean, whatever of the facility, as opposed to the long-term impact that most businesses are seeing as a result of wide-scale shutdowns that are interrupting their business. If your coverage allows for an extended period of time for the business to resume normal operations, that would certainly be more beneficial in our current scenario, because many businesses are going to take months to resume normal operations. And then, of course, the question is, what is normal operations, and how does your policy assess that? Beyond typical business interruption coverage, many policies will include a coverage endorsement for interruption caused by orders by civil authorities. This is certainly applicable right now. In most states, there is some form of a shelter-in-place, lockdown, non-essential business closure order. The coverage would apply to perils arising out of actions of civil authorities. Unfortunately, in the case of a lot of these civil authority provisions, it is still required that action by a civil authority be based on actual physical damage to property. So, for example, the most common scenario may be, there is damage to a roadway as a result of a storm or an earthquake, and local authorities shut down that roadway for a couple of weeks while repairs are done, and therefore your business is inaccessible. Clearly, there was a lot of claims related to civil authority coverage in the wake of 9/11. Businesses that were, within quarantine zones in Lower Manhattan and were subject to civil authority orders that restricted travel may have had coverage under this type of provision. This will apply to government or military authorities. Doesn't matter, statewide, local, municipal authorities. The key piece usually is that some civil authority has restricted access to the insured's property, but depending on how the provision is worded, it may only apply where that restriction is based on an actual incident of physical loss, physical damage to the property as the basis, the impetus for that restriction. Now, that's where looking at the state-by-state orders that we've seen is important. Wisconsin's Safer at Home order, I was just reviewing the updated version that I think came out April 16th, specifically notes that COVID-19 is present throughout Wisconsin, and it lists that as the basis for the restrictions. Whether insurers are interpreting that as acknowledgement of physical damage throughout the state or not clear. Haven't seen a lot of instances of civil authority coverage based on the Safer at Home order providing coverage for losses, but it'll be interesting to see how that continues to shake out, particularly as we see challenges to the current order. As discussed a minute ago, contingent business interruption can also protect against disruptions in your supply chain, even if they don't occur at your facility and with your business. This is going to provide coverage if suppliers or other companies that your business relies on are shut down due to physical damage to property. Again, the key component here frequently is going to be that there is actual physical damage to property. So if your supplier of a certain part or product or raw material has had to shut down because they had a coronavirus outbreak within their plant, your losses related to that shutdown, related to the inability to access that raw material, may be covered under a contingent business interruption policy. In some cases, that's also going to include the loss of market for your product if your customer's property is damaged. So, for example, if you have a very specific product in a very specific market that you deliver it to, and your customer is completely shut down, you may have coverage under a contingent BI policy. One interesting area that I think we'll be seeing is vendors for large-scale events that have been canceled as a result of safer at home orders, vendors for sports leagues and stadiums, vendors for entertainment venues may have claims under contingent business interruption policy where they have no market for their particular product. You think about the large-scale food vendors that service Miller Park, Fiserv Forum, are not themselves shut down necessarily, but their market is completely lost as a result of the civil authority order. So it's possible that there may be coverage there. Currently, the landscape that we're looking at, generally we've heard insurers are preemptively stating that COVID-19 losses are not covered. A lot of insurance industry groups have come out and been very upfront about that. Most business interruption claims that we're seeing filed by small businesses are being denied across the city and state here in Wisconsin. We've seen a lot of stories about business interruption claims filed by restaurants, bars, and without specific instances of contamination in their facility, those have been typically denied. The insurance industry representatives, trade groups have insisted that that's for good reason. These exclusions that would cover broad-scale business shutdowns are in place for a reason, that insurers are simply not capable of paying out to every insured business at the same time. The industry would say, in the case of a hurricane, you've got a concentrated group of businesses in a particular area of the country that has lost business, but in the case of a pandemic, an epidemic, you're going to see across-the-board shutdowns, and that's the reason for those types of exclusions. There had been pressure and continues to be pressure for government representatives to get involved and to mandate that insurers cover certain losses related to business interruption. Here in Wisconsin, the Wisconsin Office of the Commissioner of Insurance, OCI, put out a statement, and it's available on their website. Sorry, I should have provided the link here, and much longer than this, but this snippet is really the gist of it. They made clear they can't mandate that insurers insuring businesses in this state cover business interruption losses. They could become insolvent, unable to meet obligations that are currently included in their contracts if they're required to provide essentially extra contractual coverage. So we've seen similar statements from insurance commissioners in other states. The conclusion seems to be within the industry that insurers, if they were forced to cover all of these business interruption losses, would potentially be unable to deal with, for example, a hurricane season that we have coming up, a wildfire season that we probably have coming up. So there's some concern about them being able to meet existing obligations if they're forced to cover these losses. But that has not necessarily kept legislators from pushing for this. Whether legislative action has been more of a signaling approach of support for the business community, or whether there's real hope of getting this legislation passed. We have seen in 7 states thus far bills introduced that are working their way through state legislatures that in some fashion or another would require that the insurers pay out business interruption coverage on policies in which there is a business interruption provision, and if the losses are related to the coronavirus and to business shutdowns and shelter-in-place orders. There's also federal legislation on this topic. In the case of both state and federal bills, they're likely to be challenged in court by insurers, and it's likely that process will drag for some time. There's certainly constitutional issues at play there if the legislature is getting involved in essentially changing the terms of contracts between insurers and their insured. But you see a lot of state and federal legislators eager to take some kind of action even in cases where they are guaranteeing repayment of insurers by the state or by the federal government on these payouts for business interruption coverage, but they're anxious to take some kind of action. It's unlikely that that's going to go anywhere anytime soon. The other piece of that is we're seeing a wave of lawsuits by businesses against insurers in both federal and state court. There's a number of proposed class action cases that have been filed in federal courts around the country, many by the same firm that is seeking out businesses that have been denied coverage under their business interruption policy. Here in Wisconsin, there are two cases against Society Insurance, a Wisconsin-based insurer, one in federal court. Here in the Eastern District of Wisconsin, Rising Dough Incorporated, I believe, is a Madison-based bakery. There are a number of other plaintiffs that have joined on that case, and they are seeking to have a class of businesses certified. Likewise, in state court here in Milwaukee County, Colette-Thibault Coffee, along with, I believe, the Tandem restaurant, has brought a claim against Society Insurance, similar grounds that they were required to shut down. They were prohibited from staying open for dine-in service, and they had paid premiums on business interruption coverage for however many years and had their claims denied. Again, the attorneys there seeking certification of a class of Society Insurance insureds. So we'll continue to monitor those cases. I think that you'll start to see some of them consolidated. It'll be interesting to see whether courts certify these classes. Many of them will probably continue to be in the restaurant and hospitality industry. Those are, instances where these businesses have the most in common, and it's probably easiest to put together a class of similarly situated insured businesses. And it'll be interesting to see whether there's any progress made there. But as far as what your businesses should be doing at this point in time, review your policy language carefully. If you haven't already, do so. I'm sure most of you have, including all endorsements and exclusions to determine if there's possibly coverage. If you're unsure at all, it's best to go ahead and file a claim with your insurer. And looking forward, carefully review your liability coverage, not just for, obviously losses that you may have had due to interruption to your business, but forward-looking as businesses reopen. Make sure that you're appropriately covered for liability risks that you may have for customer exposure to infection on the premises. While employees infected in the workplace, contracting coronavirus in the workplace, are likely going to fall under workers' compensation, the subsequent infection of an employee's family may give rise to a claim if there is an argument that there were inadequate safeguards for employees at the business. So that's going to be a critical piece to make sure that you're appropriately covered, particularly in the retail and hospitality sector, where you may be bringing in a lot of people once businesses reopen, and there's certainly concern about another wave of infections. I'm not seeing any questions as of right now on the insurance piece, so I'm going to move quickly into suspending contract obligations and then try and wrap this up and hand it off because I see that I am already starting to move a little bit long. We're going to talk about a couple of different circumstances that may apply to your existing contracts with both vendors and with customers. The first of these, force majeure, impossibility, then frustration of purpose, and commercial impracticability. Force majeure, many of you are probably familiar with the common clause in commercial contracts. That's going to excuse one or both parties from performing when circumstances beyond their control intervene. These clauses can be very broad, or they can be very, very specific and refer to specific scenarios. The language is going to control here what is in your contract. It may protect one party, it may protect both parties, depending on how the contract was drafted. Might refer to specific things like strikes, acts of terrorism, might simply refer to acts of God. I suspect there may be litigation as to whether or not the current circumstance falls under the act of God phrasing. I haven't seen any existing cases yet, but I wouldn't be surprised. So look at the specific language that you have. Does it include pandemics, quarantines, civil shutdowns, etc.? When you have a clause in your contract, the language of that is going to control. Where there's not a specific clause, there are a few different doctrines under the law that may allow a party to get out of performing a contract. The first of those is impossibility. This is a condition that both parties assumed would continue at the time that they entered into their contract. It was some fact that they were basing their contract on, and that fact ceases to exist. And therefore, it's impossible to perform. Courts aren't going to enforce an obligation on a party that it's simply impossible for that party to perform. This usually has to be objectively impossible. So not just hard to perform, but literally impossible. I'll give an example of a couple of Brewers examples here because that's on my mind. An entertainment company books a performer to sing a national anthem at the Brewers home opener. Obviously, that game was canceled. It's impossible for that singer to perform. They can't carry out their contract. They can't just show up at Miller Park and stand in the outfield and start singing. That is objectively impossible for them to perform, for either party to perform under that contract. Slightly different, but same concept, is frustration of purpose. Contractual performance might remain possible, but performing the contract would produce a different result than what the parties anticipated. So, you entered into a contract for one reason. There was a specific goal or purpose that you had, and that's no longer possible because of a contingency that came up. So again, an example for our current scenario here, your company decides to book a shuttle bus to take all your employees over to the Brewers game. The game is canceled. You could still take the shuttle bus. The shuttle bus company says, hey, we're still in operation. Come meet us in the parking lot. We'll hand you the keys. You owe us $2,500 for the bus, but the purpose of the bus reservation ceases to exist. In this case, it's pretty critical that you're able to establish that the parties understood the purpose of the contract. So, where you have a contract just generally to rent something, it may be tougher to make that argument. Where a bus company specifically markets to you, Brewers, tailgate shuttles, and it's clear what the purpose was, that it's an easier case there to show that that purpose is frustrated. And again, on these, the idea is that you're no longer obligated to perform. It may affect both parties. Both parties' purpose may be frustrated, but it may only affect one party. The final one we'll talk about here is mostly in a sales and supply chain context, but commercial impracticability. This really gets to where something has come up that makes that's unforeseeable, that makes performance impracticable. Not impossible. It's still possible to do, but it's so commercially impractical to perform that you should be excused from performing, or at least you should be excused from a delay. This comes up a lot of time with supply chain disruption. So, based on an unforeseeable contingency, based on a safer at home order that has shut down one of your supplier businesses that's deemed non-essential, you can no longer get a particular material. Your performance to make your product is now impracticable. The key piece here is that the contingency has to be unforeseeable. And impracticable doesn't just mean it got more expensive to perform. In a lot of cases in a supply chain disruption, and we've dealt with clients over the last 6 weeks that are dealing with this, we've explained that you've got to go out and seek out alternative sources. If the only thing that has arisen is your sole source on a material, or your sole vendor is out of business because of the coronavirus, losing a source, having some sort of disruption in a sole source situation is not completely unforeseeable. And so there may be litigation on that point where businesses are arguing that they can't perform or they should be allowed to delay, and their customers are saying, no, you should have had a contingency plan. You should have had a backup in case one of your suppliers went down, because certainly you could have a disruption in supply chain that is unrelated to a pandemic. So that is an area where we expect to see some litigation. What should your business do? Again, it goes back to reviewing your contracts, just like your insurance policies. But review your supplier contracts and your customer contracts. Be aware that you could have a force majeure or an impossibility and practicability claim being made by someone up your chain. One of your vendors, one of your suppliers is telling you that they should be excused from performing. In the event that you can't meet your production requirements, maybe you have a number of customers, be prepared to allocate among those customers. In the case if you make a particular product and you sell it to 7 different retail stores and you can't meet all of their orders because of your production limitations, the law says that you've got to come up with a reasonable allocation plan. So you can't just play favorites and send everything to one of them and expect to be excused from all your other contracts. You've got to find a basis to allocate between them. Usually, manufacturers will base that on, trailing demands from those customers. What do they have over the last 12 months or something to that effect? You also need to make sure that you're researching sourcing options if you've got some kind of shutdown or disruption, and keep good documentation of your efforts to mitigate the disruption. So if you have a delivery, mechanism that is now shut down, your delivery drivers are no longer available, or you've got a supply source that no longer is in business, whatever you're doing to track down new ones, document that. Because to the extent that you end up in a lawsuit over the extent to which you've been able to perform a contract, you're going to want to show, here are all of the things that we did in order to try and perform this. We took reasonable steps. We sought out alternative sources. And, communicate with your suppliers and customers. Always a good policy anyway. And there's no reason to completely clam up now. Open lines of communication will probably smooth out any concerns about disruptions. If you've got customers that you can't fill complete orders, explain to them the circumstances. Don't just say coronavirus and throw your hands in the air. Explain to them, here's the sourcing situation we're in. Here's what we're trying to do. Alternatively, here's why we can't provide this service to you like we agreed to do, but we're going to try and do something different. If you end up in a dispute, courts are going to look favorably on parties that acted reasonably, that acted promptly, that communicated effectively with their vendors and with their customers. So continue to try and do that. If there's no other questions on either the insurance piece or on the contractual challenge piece, I am going to go ahead and hand this over to Shannon. If you do have questions, please fire away, and we can get to those at the end of the presentation as well. So at this point, I am going to hand over to Shannon, and we'll talk a little bit about the Families First Coronavirus Act.
Thanks, Guy. So as Guy mentioned, my name is Shannon Toole. I am an attorney in our labor and employment group at Reinhardt. Excuse me. As Guy mentioned, I'm going to be, sorry, my PowerPoint, technical difficulties. I'm going to be discussing the Families First Coronavirus Response Act. This is something that I know a lot of employers have been dealing with since it came into effect on April 1st. So what I'm going to do is provide an overview of the Act and then address a couple of questions that have come up specifically related to, issues of enforcement and also of, how do we administer the leave to employees. So we'll start with a brief overview of the timeline of the legislation. So on March 18th, the FFCRA, or Families First Coronavirus Response Act, was signed into law. On April 1st, the law went into effect, which is when employers were supposed to begin administering the leave to qualifying employees. April 17th is actually when the Department of Labor was said it was going to begin enforcing the leave. So this is actually something interesting. Right after the law was signed, the Department of Labor, along with, I believe, the Department of the Treasury and one other department, came out and said, we're not going to enforce this law for 30 days. So basically there was a grace period between April 1st and April 17th where the DOL said, we will not enforce this law. That period has obviously ended, and the DOL has now started issuing more information about their enforcement, which we'll touch on a little bit later. December 31st, 2020 is when the FFCRA coverage ends for employers. So what this means is the leave that is available to employees under this law is available until December 31st, 2020. And unless we hear otherwise from Congress, after December 31st, 2020, employees will no longer be able to take leave provided by the FFCRA. So who does this law apply to? The FFCRA covers employers with fewer than 500 employees in the United States. So this is an important distinction because there are many employers that are potentially owned by a foreign parent company or have employees outside of the US. When you're determining whether or not you are covered, you look at your employees in the United States. Something else that is important for employers to keep in mind is when you are determining how many employees you have and whether you're covered, the count begins when an employee requests or takes leave. So you have to do the count for each individual employee as opposed to just saying, well, on average, we have 500 employees, therefore we are covered or are not covered by the law. And when you're counting employees, you're including several different types of employees. You're including full-time employees, part-time employees, employees on leave, temporary employees, and day laborers supplied by a temporary agency. So there are two types of leave that is provided under the FFCRA. We have emergency paid sick leave and expanded family and medical leave, or EFMLA. I'm going to address each one of these in turn, and then I'll talk a little bit about the tax credit available to employers under this law, and then I'll talk about enforcement and administration of leave. Beginning with emergency paid sick leave. So, an employee qualifies for EPSL if he or she meets one of 6 conditions. And something that I want to note that is of importance for this particular type of leave is that there is no limit on how long an employee has been employed for him or her to take leave. This is a little different than the EFMLA portion, which does have a length of employment requirement of 30 days. And we'll touch on that a little bit later. But so your employee could have been employed for 1 day if they work for an employer with less than 500 employees and they qualify for one of the 6 conditions, then they can take the leave. So now I'm going to go through those 6 conditions and point out some notes and some clarifications that the Department of Labor has provided for each one. So the first 3 reasons an employee can take emergency paid sick leave are the employee is subject to a federal, state, or local quarantine or isolation order. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, or the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Starting with the first reason, the quarantine or isolation order. This can include shelter-in-place or stay-at-home orders. This was not initially mentioned or clear in the text of the law. The Department of Labor has, since the law passed, said that this can include shelter-in-place orders. However, an employee only can take leave due to a shelter-in-place or stay-at-home order if the employee isn't able to work because of the order, even though his or her employer has work that the employee could perform. So, for example, if Wisconsin amended their shelter-in-place order to say persons over 60 should not leave their homes for fear that they can more easily contract the coronavirus, that would be an instance where that person is subject to a quarantine or isolation order and could otherwise go to work at their job, assuming there was still work available, but for that order. Otherwise, the employee cannot use that condition to take leave. So say, for instance, you are currently, your business is not operating or operating on a reduced schedule because of the quarantine or isolation order. That's not a basis for the employee to take leave. The quarantine or isolation order has to personally affect the employee and personally prevent the employee from going to work. For the second condition, the Department of Labor has provided a little bit of clarification on when employees are advised by healthcare providers to self-quarantine. There was a little confusion at the beginning when this was passed because there wasn't a specific condition for leave that said the employee has COVID-19. That would likely fall under this category. So the Department of Labor has said an employee can satisfy the second condition if they are advised to self-quarantine because they have COVID-19, they may have COVID-19, or they're particularly vulnerable to COVID-19. And finally, with this third condition, the employee has to both be experiencing symptoms of COVID-19 and seeking a medical diagnosis. I believe it was on the 27th, the Centers for Disease Control came out with more symptoms for COVID-19. So an employee, previously it was fever, dry cough, and shortness of breath. Now there are 6 additional symptoms an employee could be experiencing. So if the employee is experiencing one of those 9 symptoms and they're seeking a medical diagnosis, which means they're affirmatively taking steps to make an appointment, get a test, go to the doctor, then they may qualify for this portion of the leave. The fourth reason an individual can take leave under emergency paid sick leave is that they are caring for an individual who is subject to a federal, state, or local quarantine or isolation order, or that individual has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The Department of Labor has clarified that who an individual can be that the employee is caring for. So it can be an immediate family member, a person who regularly resides in the employee's home, or a similar person with whom that employee has a relationship with, and their relationship creates an expectation that the employee would care for the person. So, one good example is a roommate. That would be somebody who both regularly resides in the employee's home, and depending on the relationship with the roommate, that person may have an expectation that they would care for them. Furthermore, an individual is not someone with whom the employee has no personal relationship. So if the employee was said to you, hey, I'm going to take care of this person who has COVID-19, I've known them for 2 days, that's probably not going to qualify for this for leave under this section of the EPSL. The fifth reason somebody can take emergency paid sick leave is that the employee is caring for a son or daughter younger than 18 years whose school or place of care has been closed, or whose child care provider is unavailable due to COVID-19 precautions. One interesting note for employers and something that's not actually included in the Department of Labor regulations or the law, but something that the IRS has said, is that in order to actually get tax credit for this leave and all the other leave under the FFCRA that employers are paying for, employers have to collect certain information from employees. For this condition specifically, the IRS has said that for children between the ages of 15 and 17, the employee must provide a statement that special circumstances exist that require the employee to care for the teenager during daylight hours. So basically, this seems like an assumption that children between 15 and 17 are more capable of taking care of themselves, and it requires an extra certification that you need the leave in order to take care of these kids. Finally, the sixth condition, the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. If you are confused about what this means, you are not alone. There has been no clarification as to the state regarding what precisely this means. So if an employee requests leave under this particular condition, I would suggest reaching out to an attorney to discuss this because the Department of Labor has specifically said it has the right to clarify what this means at a later date. It has not yet clarified what it means. So if an employee comes to you and requests leave using this particular condition, I would certainly contact an attorney who can help you navigate that situation with that employee. So how much leave is available? So for EPSL, full-time employees can get up to 80 hours, whereas part-time employees get the average hours worked over a 2-week period. There are, the Department of Labor has put out some really helpful questions and answers on its website about the FFCRA and emergency paid sick leave. If employers have questions about how to calculate the average hours for part-time employees over a 2-week period, there's some really great guidance on that. If you're still having trouble, I would suggest reaching out to your attorney who can help you get clarification on exactly how many hours part-time employees should be receiving. Finally, how much are we paying employees? So there is a cap on how much employees can actually be paid while they're taking both EPSL and EFMLA. So for emergency paid sick leave, for those first 3 conditions that we talked about, which have to do with, how is COVID-19 affecting the employee personally, employees who take leave under those conditions should be paid at their regular rate of pay, but cannot receive more than $511 per day, or $5,110 in total. For employees who take leave for any of the other reasons we discussed, so conditions 4 through 6, they are paid at 2/3 their regular rate. However, they can be paid no more than $200 per day or $2,000 in total per employee. All right. So EFMLA, or Expanded Family and Medical Leave. So what's interesting about the FFCRA in this particular portion is because it applies to employers with fewer than 500 employees, this actually means that this particular portion of FMLA has been expanded to employers that are not usually otherwise covered by FMLA. So if you are an employer and you normally don't meet the standard to administer FMLA to your employees, this portion specifically does apply to you. It does not mean that any other FMLA now applies to you. So to take EFMLA, the employee has to have been employed by the employer for at least 30 days, and the employee must be caring for a son or daughter younger than 18 years old whose school or place of care is enclosed, or whose child care provider is unavailable due to COVID-19 precautions. This is the only reason somebody can take leave under the expanded family and medical leave portion. This is the exact same condition as condition number 5 for the EPSL, which means that the longest amount of time or the thing that people can take the most time for is to care for their son or daughter, because of all these school closings, which is affecting a lot of people and will continue to affect a lot of people throughout May, June, and we might be potentially looking at this into the fall as well. So employees can take up to 12 weeks of EFMLA. The first 10 days of the leave are unpaid. The remaining portion of the leave is paid at 2/3 the employee's regular rate, or $200 a day, with a maximum of $10,000 total per employee. And I want to just point out too, for employers who already are covered by FMLA, this 12 weeks is not an additional 12 weeks of FMLA for your employees. This 12 weeks is included in just that chunk of FMLA that employees would regularly receive. So if during the 12-month period your employee has 12 weeks of FMLA, typically that they would already have to say, take it for a serious health condition or to care for somebody with a serious health condition. And that employee has already taken 6 weeks of FMLA to, care for somebody with a serious health condition. They only have 6 weeks of FMLA remaining, including to take this EFMLA. So they would only be able to take up to 6 weeks of EFMLA to care for their child if they've already used some of their allotted FMLA time. Oh, apologies. So, as with FMLA, employees have the right to return to their positions when the EFMLA expires. There is an exception for employers with fewer than 25 employees. This exception applies when an employer with fewer than 25 employees must eliminate the position due to economic circumstances caused by the COVID-19 pandemic, and there is no equivalent position available. So if you have fewer than 25 employees and you're forced to get rid of some positions permanently, and that employee who would have otherwise been in that position is on EFMLA, you don't have to give that person a job because their position has been eliminated. Again, this is only for employers with fewer than 25 employees. Fewer than 500 and above 25, you do have to return that employee to their position. So I'm going to briefly touch on the tax credit associated with the Families First Coronavirus Response Act, which should really help employers who are having to administer this leave to employees. I will say at the outset, I'm not a tax attorney. So if there are more specific questions about the tax credit, or you would like to reach out to somebody, I have provided a few links at the end of this section with more detailed resources. It's my understanding this presentation will be sent out to attendees afterwards, so you will be able to access those links directly. So briefly, employers may claim a tax credit against the employer portion of Social Security taxes for up to 100% of leave wages paid by an employer for leave offered under the FFCRA. So what this means is if you administer leave to an employee, you should be able to get a tax credit for the amount that you paid that employee while they are on leave. To claim this tax credit, as I mentioned, the IRS has said that employers need to obtain specific information from employees. That information at baseline is the employee's name, the date or dates for which leave is requested, a statement of the COVID-19 related reason the employee is requesting leave, and written support for such reason, and a statement that the employee is unable to work, including by means of telework, for such reason. There are, under the IRS guidance, some additional information you can ask employees for. For instance, if an employee is requesting leave because they're subject to a quarantine order, employers can request the name of the governmental entity that has issued that order. Reinhardt has developed a form that employers can use. It's a model form that already includes all the necessary information that employers need to request. If you're interested in discussing or using that form, feel free to reach out to myself or anybody else on this presentation or any Reinhardt attorney, and we can help you out. And then these are the links that I mentioned that will be available once the presentation is sent out. So now I'm going to touch on two topics that have come up a lot with regards to this leave: intermittent leave, employers with fewer than 50 employees, and then I'll briefly touch on enforcement of the Act. So there are different rules for intermittent leave depending on whether or not an employee is able to telework. So for employees who are unable to telework, meaning they cannot do their job at home, for example, say an employee who works on a factory line, that employee can take intermittent leave under limited circumstances. And that circumstance, those circumstances are the employee is caring for a minor son or daughter whose school or child care provider is closed or whose child care provider is unavailable, and both the employer and the employee agree to the intermittent leave. So this is important because this means that if one of your employees who can't telework requests to take intermittent leave to care for their child, so say they wanted to take a half day instead of taking a full day, you have to agree to that in order for the employee to be able to do it. So if that's not possible, it's not something you want to do, you do not have to let the employee take intermittent leave for that particular reason. Now, for employees who are able to telework, they can take intermittent EPSL or EFMLA for any qualifying reason, as long as both the employer and the employee agree to the intermittent leave. So this means that, if you're able to telework and you want to come up with an agreement with the employer where you work from, say, 9 to noon, you don't work from noon to 3, and then you work from 3 to 6. That's possible for any of the reasons you're taking leave, as long as the employer and the employee agree to it. This is much broader than the people who are unable to telework. And the Department of Labor has said the reason that it is much broader is because the purpose of the leave is to provide time off for people who are sick, caring for people who are sick or otherwise should not be going outside because they're vulnerable to the virus. So that is the reasoning behind that. There is an exception for employers with fewer than 50 employees in terms of administering the leave. So an employer with fewer than 50 employees does not have to administer EPSL or EFMLA with regards to employees taking care of their children if providing that leave would jeopardize the viability of the business as a going concern. So what does this mean? The DOL has put out 3 reasons that, providing this leave for childcare, for taking care of children would jeopardize a business as a going concern. They have to do with, would it put the business in basically financial ruin? Would there be enough workers to actually keep the business going? And would it cause the small business to operate in a minimal capacity or cease operating altogether? If you believe you qualify for this exception, you have to have an authorized officer of your company, so CEO, president, CFO, actually make that determination. There is nothing that you have to provide to the DOL directly, but make sure that you are keeping those records in case the DOL were to come to you and say, hey, we noticed you haven't been administering this leave. Why? And that leads me to my final point, which will be brief, which is enforcement. As I mentioned at the outset of this presentation, enforcement began on April 17th, 2020. Employers should be aware that failure to provide leave or properly compensate employees for leave can result in monetary penalties. The penalties are under the Fair Labor Standards Act, and they have just been folded into this particular leave. And they could be somewhat substantial if there are a large number of employees who have not been properly compensated or have not been provided leave. Thus far, I have not heard of any specific enforcement actions by the Department of Labor, but that doesn't mean that they are not happening. So just something to be aware of. Make sure that you're administering the leave properly, and if you have questions about the leave, to consult with your attorney. And I see that I have one question. Somebody asked if remote work affects the fifth reason for emergency paid sick leave, so childcare. I believe I touched on this, which is that you can have somebody take intermittent leave, or somebody can take that leave if they're working remotely. Understandably, there may be instances where the person can still telework and care for their child. It's more that if they need time, specifically where they are not working, they can work that out with the employer so that they can take intermittent leave throughout that time and change the schedule. So it is possible for employees who are unable to telework to take EPSL to care for their children. But it is important to note that the employee has to certify that they're unable to work for telework because of that condition. So if an employee says, I have a 17-year-old, that occasionally needs to talk to me during the day, that probably wouldn't qualify as being unable to telework. But if they have a 3-year-old that they need to, really pay attention to for multiple hours during the day, that would likely qualify as, okay, they are unable to telework. So I am now going to hand this over to my colleague, Christopher Sheely, and he will round us out.
Wonderful. Thanks a lot, Shannon. Again, my name is Christopher Sheely. I'm an associate in our firm's Labor and Employment Department, and I am here to speak to you all about the CARES Act. But in addition to the CARES Act, other pieces of COVID-19 legislation and what those pieces of legislation mean for Wisconsin employers. Like Shannon, I'd like to begin. Oh, I got to show my screen here. That would be a good start. Let's see. Okay. Like Shannon, I'd like to start off with a timeline just to give all of our listeners just a little bit of perspective on where we've been and where we are now. I was a student of history in college, and it's just amazing to me to think of an event like this in our country's history that's happening in a matter of weeks and months, not years, but rather have the scale of impact that's one for generations. This coronavirus has really impacted the United States since the beginning of March. That's when we started to see the legislature and Congress move to directly address the COVID-19 pandemic in the United States. From March 3rd to about mid-March, we saw two pieces of legislation pass through Congress: the Coronavirus Preparedness and Response Supplemental Appropriations Act and the Families First Coronavirus Response Act, which Shannon just spoke to. By March 19th, we saw some shelter-in-place orders being issued by states like California, New York, and later in the following week, Illinois and Wisconsin, among others. By the end of March and early April, we really started to see things ramp up in the form of stimulus packages, specifically the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act, as it's known today. By April 15th, we see the Wisconsin legislature passing a stimulus package as well. That would be Act 185. And by April 24th, so that's last week, we see another stimulus package passing through Congress, which I'll touch on a little bit, sort of an addendum to the CARES Act, if you will. So I'd like to start with this first Coronavirus Preparedness and Response Supplemental Appropriations Act, which unfortunately does not have a very catchy acronym. There's not too much here that's relevant for private employers, but I think just the matter of scale is very interesting. This particular stimulus package is about $8.3 billion for federal agency response to the coronavirus pandemic. About 81% was going to our domestic response, and about 19% going to international response. Again, but keep that number in mind, 8.3 billion with a B. Shannon just spoke to this, but the Families First Coronavirus Response Act followed by mid-March. It expands Family Medical Leave Act by requiring employers with fewer than 500 employees to provide up to 12 weeks of partially paid family and medical leave to care for children due to school or daycare closures. And then we also heard Shannon speak to this emergency paid sick leave 2-week requirement under the Families First Coronavirus Response Act as well. After we saw a handful of states issue safer in place or a shelter in place or safer at home in Wisconsin orders, we see Congress pass the CARES Act. And that's really the focal point of my presentation and really the United States government's response to the pandemic in the United States. This is a $2 trillion stimulus package. And I know that we've thrown that term around quite a bit here, but I've got a graph coming up on the next slide just to show you by matter of scale what exactly we're talking about here and the amount of money that's really being injected into the economy. And it just shows, again, the scale of the situation we're dealing with as far as our national response. I've highlighted 3 key provisions for small employers. The first is sort of the flagship provision. It's the Paycheck Protection Program, or the PPP. About $350 billion were allocated to that program pursuant to the CARES Act. Second is the Economic Injury Disaster Loan Emergency Advance provision, about $10 billion. And then expanded unemployment insurance benefits, about, $250 billion designated for that particular response. I'll go into each of these in more detail, but this just gives you a framework of where I'm heading. Now, I mentioned that graph before. I've got 2 slides here back to back, and it's a vertical chart that shows you just where and how much these different pieces of the CARES Act puzzle, where it fits into the entire scheme. I mentioned just that last point, unemployment benefits. You'll see the second point on the right is $260 billion for expanded unemployment benefits. Just above that, you'll see the cash payments to individuals. Many of you may have seen that or heard of that on the news about checks going to individuals who make less than approximately $100,000, checks for parents of young children. And if we move down, and you see here too, I shouldn't move on too quickly here, $425 billion for large corporations. That's being administered by the Federal Reserve on sort of a different playing field than the PPP, which is designed for or designated for small employers. And that's what we see here at the top of this second slide, $350 billion in new loans for small businesses. That $10 billion in grants to below, that little sliver, that's for those emergency disaster economic advance pieces that I referenced as the second point that I will address later. Again, I asked you to remember that $8.2 billion stimulus package that was initially passed by Congress for the national and international response to the coronavirus pandemic. Well, you see that's less than just this small little sliver of a grant piece. It's amazing to see just the economy of scale of how quickly the U.S. government ramped things up in the course of less than a month. So let's talk a little bit about the Paycheck Protection Program. In essence, the Paycheck Protection Program is a means for the U.S. government to get small businesses money in order to cover, among other things, payroll. Right now, we're seeing lots of businesses affected by the pandemic in the shape of closures, forced or otherwise, decreased orders, decreased business obligations. Companies need cash. They need cash to keep the lights on and to keep their processes moving. So who's eligible? Typically, it's a business with 500 or fewer employees, businesses who satisfy the SBA's size standards, which could be different than that 500 employee standard, depending on the industry, the NAICS code that the business is incorporated under. Interestingly, and maybe some of you have heard of this in the news as well, there is an exception in the CARES Act for businesses in the hospitality and the dining industries. That's those that are incorporated under NAICS code 72. Those are the first two digits of the NAICS code. The standard for those industries are 500 or fewer employees per location, not overall. And that's how a company like Shake Shack, which has been in the news quite a bit recently, was able to get a PPP loan despite having about 8,000 employees. The reason for it is it's clearly incorporated under a NAICS code that begins with 7 and 2. And these employees, these 8,000 employees, are spread out among about 189 restaurants. I'll get to the public response to Shake Shack getting this amount in a little bit, but for those of you that don't know, Shake Shack actually did return the PPP loan that they received after the public got wind that such a large company were to receive a small business loan and take that away from a smaller business that may need it more. And I can discuss that in a little bit. But before I do, I'd like to take just a quick poll. I'd like to ask two questions. And the first question is, did you or your company apply for a PPP loan? And then the second question will be, if the answer is yes, I'd like you to secondarily answer, did you or your company receive a PPP loan? I'm just curious to see, again, who's interested in this program, who applied, and if anyone received. So I'll give you 30 seconds to answer that first question. Okay, I'm going to take a peek here at the poll. And I see, from what I see 52% of you voted, so thank you to those of you who did vote. And I see that the majority of you did apply for a PPP loan, 64%. And now if I could open up that second question, so for the 64% of the respondents who answered yes, did your company receive a PPP loan? All right, the results are coming in. And they're settling in right now as the vast majority, yes, 67% did receive a PPP loan. And for me, that's encouraging. It stands to reason that the program is achieving what it was designed to do, at least for the 67% of you. But the 33% that answered no, well, first of all, I'm sorry to hear that. But secondarily, I think that the federal government is taking steps, at least right now, to make sure that you may have a second crack, depending on the reasons for why those funds didn't arrive at your bank account. So let's say you get the PPP loan funds. What can you use it for? Well, what you can use it for is one thing. But the key provision of this PPP program is that these loan amounts are 100% forgivable depending on how you spend this money. So first, I'm going to deal with what you can spend the money on, and secondarily, what can you spend the money on and have that amount be forgiven, because they're not the same. Permissible uses of PPP loan funds include payroll costs, continuation of group health care benefits during periods of paid sick, medical, or family leave, and insurance premiums, interest on mortgage obligations, rent, lease agreement payments, utilities, and interest on debt incurred before the loan origination date. Now, what costs are forgivable? That's payroll costs, interest on mortgage obligations, rent or lease agreement payments, and utilities. That's it. The idea behind this Paycheck Protection Program is to keep companies afloat through this uncertain time. Notably, the interim guidance that's been published on the Paycheck Protection Program has clarified that 75% of the PPP loan must be spent on payroll costs in order for it to be forgiven. So let's say there are, huge utility and rent and lease obligations for the company. The company can't spend, let's say, for example, 50% of the PPP loan funds on utilities, rent, or lease obligations and expect the whole amount to be forgiven. At least 75% of the loan obligation needs to go towards payroll costs. And after all, that's exactly how the amount of the PPP loan is calculated. It's 2.5 times the average monthly payroll costs that the company incurred over the previous year, the year prior to submitting that application. So the idea behind 75% is 2.5 times the monthly payroll will get you through 10 weeks. The covered period is 8 weeks, 75%. So the 8-week period approximately should be covered by the loan, and there should be a little extra on top to go towards rent and utilities, things of that nature. Note that in order for this loan to be forgiven, there are limitations as far as what an employer can do with respect to its employees. The employer cannot reduce the current number of employees during the covered period. Again, the idea being that if you're getting this loan funding from the federal government, you should be able to keep all of your employees and pay them. So terminating employees or laying them off during the pandemic would be the opposite of what this piece of legislation is designed to do. Similarly, cutting wages by 25% or more would also run contrary to the PPP. Second piece that I'd like to address from the CARES Act is the expansion of Economic Injury Disaster Loan Program administered by the SBA, or the EIDL. This program is expanded through December 31st, which will allow more employers to access loan funding through the SBA. Those loan funds can be up to $2 million per applicant, 3.75% interest, up to 30-year terms. These are not PPP loans. These are additional loans that would have to be paid back to the SBA. But again, more people are eligible for these loans. The interesting piece, and I mentioned this as a $10 billion allocation in the CARES Act itself, is the EIDL Emergency Advance, which issues grants of up to $10,000 per applicant for any entity that is applying for an economic injury disaster loan, regardless of whether you get the loan, which is amazing. So you're good for $10,000 just by submitting an application for a loan. So another way for at least some small semblance of cash to come through, and that's up to $10,000, not necessarily a guarantee. Finally, and this has become an interesting point of emphasis for many employers, is how the CARES Act has expanded unemployment insurance benefits. Typically, at our firm, we don't deal a whole lot with unemployment insurance questions just because it's sort of in the periphery of other issues that we tend to deal with more. But now, with so many employers wanting to make sure that their employees are taken care of, in case there is a need for a temporary layoff or a furlough, or even just determining how exactly to manage their human capital, unemployment insurance benefits and the relevant law in the state and the federal level has become critically important. The CARES Act has effectively supercharged the unemployment programs in every state across the nation. And it did that in three major ways. The first way has become very popular and has been parroted over and over across various news outlets, is that unemployment insurance benefits have been increased by $600 per week through July 31st. That's for weeks of unemployment through July 31st. Just to give you an idea, the maximum amount of unemployment benefits that an individual is eligible for under Wisconsin law is $370 per week. So if an individual has been terminated and is owed the maximum under Wisconsin unemployment law, which is $370, you stand to gain about $1,000 per week in unemployment. That's an incredible amount of money. And the idea here is that this sort of unemployment, or this period in time, it's not really appropriate to have unemployment be simply a stopgap for individuals who have lost their jobs. It's near impossible for individuals to get a new job at this point, given the unavailability of work. So really, the $600 per week is designed to be a wage replacement measure to last out this pandemic, at least through July 31st. In addition to that, the CARES Act has also provided an additional 13 weeks of unemployment insurance benefits. That's on top of for example, under Wisconsin law and many other states' laws, the 26 weeks that's guaranteed of unemployment benefits. So that increases the amount of unemployment benefits, the weeks of unemployment that an eligible applicant could receive from 26 to 39 in the state of Wisconsin. And third, providing a full 39 weeks, and that's designed to mirror the 26 plus 13 weeks for typical applicants, providing 39 weeks to atypical unemployment insurance applicants through December 31st. Now, who's an atypical applicant or someone who would otherwise be ineligible for unemployment? think independent contractors, individuals in the gig economy, the self-employed, and interestingly enough, individuals who have exhausted their unemployment benefits under Wisconsin law or the applicable state's law. Now, in order to be eligible for this additional category of unemployment, the individual has to satisfy one of, I believe it's 12 or 13 different reasons for unemployment, and they are all related to the COVID-19 pandemic. So, for example, an individual is typically eligible for unemployment because they have lost their employment due to no fault of their own, because they're fired, for example. Well, for an independent contractor, they wouldn't be fired per se because they're not employed. But if the independent contractor has to stop working due to the coronavirus, if they have a child who becomes sick due to the coronavirus and they have to stop working, that would make them eligible for unemployment benefits, at least under the CARES Act. Excuse me. Next, I'd like to speak very briefly on the Wisconsin stimulus package that was passed relatively recently. It's a complement to the CARES Act insofar as it expands available unemployment insurance benefits under Wisconsin law. Because unemployment is a joint federal and state program, in order for Wisconsin to accept this expanded unemployment system from the CARES Act, there had to be a formal assent, which Wisconsin did, of course, accept the federal funding from the government. But in addition to that, what the Wisconsin legislature did is suspend the 1-week waiting period that's typical for unemployment insurance benefits and eligibility. And that's through February 7th of 2021. Typically, or under normal circumstances, you'd have to have a 1-week waiting period before you could collect unemployment. That's been waived, and that week that's been, I won't say gained, but moved up, if you will, by claimants under Wisconsin law. That's all covered by the federal government through the CARES Act. Additionally, employers' unemployment insurance accounts will not be charged if the cause of the unemployment was Governor Evers' safer at home order. Now, I think this is going to be very difficult from a practical standpoint for the Wisconsin Department of Workforce Development to enforce and to determine what exactly should be debited against an account and what shouldn't, and whether an employer should be dinged or not. But it stands to reason that, at least under Wisconsin law, there is a framework in place to make sure that employers are not penalized for taking action that was necessary due to the pandemic. The additional and final and maybe even feature piece insofar as unemployment insurance is concerned of this Wisconsin stimulus package is easing work-share program requirements. Maybe I should have had another poll in this survey, but I'd wager to guess that there's at least a handful of you who've never heard of work-share programs. And I'll be perfectly honest, I hadn't spent a whole lot of time with work-share programs prior to this pandemic. But I'll tell you, the work-share program that is fronted by the Wisconsin Department of Workforce Development is incredibly valuable for many employers during this particular time. What a work-share program is, it's an employer submitting a plan to the Wisconsin Department of Workforce Development stating that a particular unit or a group of its employees are going to have reduced hours and reduced pay to help the company get through a difficult financial time. What this Wisconsin stimulus package has done is it's taken this and reduced the restrictions on who is eligible for this program to the point where now an employer is eligible if 2 or more people are going to have reduced pay, and the reduction in hours is between 10 and 60% of that employee's time. So pretty broad, sweeping eligibility. And the reason why this is a huge benefit to employees is that employees receive a prorated amount of unemployment insurance benefits if associated with a work-share plan, even if they wouldn't be eligible for unemployment benefits, for partial unemployment benefits without the work-share program. So just for example, an employee who makes $500 per week or works 32 hours or more per week is just ineligible for unemployment benefits. However, if you're associated with a work-share program, for example, an employee could work, let's say, for example, 32 hours per week and earn $500 per week and be eligible for a prorated amount of unemployment insurance benefits because they're associated with a work-share program. It's a great benefit for employers. It makes filing for unemployment benefits much easier, and managing the account much easier because it's expected. And at this time, it's incredibly beneficial for employees because under the CARES Act, if you receive $1 of unemployment under state law, you also get that $600 per week added bonus. And that does apply to work-share programs. So an individual could get a relatively nominal amount in work-share benefits if associated with a work-share program, but they're going to get $600 per week on top of that. So an incredible opportunity for employers to keep employee morale up if they are faced with the decision to cut hours. Last point I want to make, because I see we're already out of time. As many of you know, the Paycheck Protection Program ran out of money on April 16th, which was less than 2 weeks after it was signed into law. As I referenced earlier, there were reports of many small businesses being denied PPP loans, and some speculate that the reason for that is because many larger companies like Shake Shack and, from, if I recall correctly, even companies like the Los Angeles Lakers received PPP funds because they did satisfy or fall under the criteria for eligibility. The government has reinserted and, frankly, basically brought it back up to the same approximate level. We've got $310 billion added to the PPP program, $60 billion of which is earmarked for small, medium, and community lenders. So if you were in that poll we had earlier, the minority group who did not receive a PPP loan, there is hope. I do recommend that you speak with your lender or submit an application directly with the Small Business Administration to try and secure those funds if you are seeking to gather those funds. One final note, and this is something that I don't have a clear answer to, but the SBA has recently published an FAQ regarding who should be applying for PPP loans. There's a piece in the SBA's application, a checkbox that states that without the loan, it's an assurance that without the loan, the company would struggle to exist, or the viability of the company would struggle, and there's a real need for this money. The SBA is all of a sudden calling into question how strict employers need to follow that guidance, or which employers would be ineligible for this PPP loan program, which is causing many attorneys to speculate, well, what if a company is doing particularly well? What if they're an essential business? Are they eligible to receive PPP funds? The SBA has given the example of a publicly traded company with access to lines of credit as being one that would ordinarily or shouldn't be eligible for a PPP loan, probably in response to Shake Shack, the Los Angeles Lakers, Potbelly Sandwich Works getting PPP funds and the vitriol that ensued. But know that issue's out there. There is guidance, I'm sure, that's on the way, but I would suspect that for the vast majority of applicants for a PPP loan, it's surely appropriate, especially to weather these uncertain economic times. So that's all I have. And Guy, I believe that I'm passing it back to you.
Okay. I think I'm unmuted now. We have had a couple of questions. Critty, I know that we did have a question here from Eric Waldron about employee counts. I apologize if you addressed that already, but are you able to see that question?
Let me see here. I do.
Are the employee counts at a legal entity level or a parent company level?
So that's a great question, and a lot of it depends. It depends very much on whether the companies satisfy, well, at least insofar as the Families First Coronavirus Response Act, there's a question as to whether multiple employers who are legally distinct are an integrated employer, whether they are joint employers of the same employee. Those analyses would all have to go on a case-by-case basis. As far as the CARES Act is concerned, that would be an analysis that's performed under the affiliate test, under the SBA's rules. It's difficult to provide, a specific tailored response on the line. But yes, there are various tests that would go into considering whether an entity satisfies one of these two standards. Interestingly enough, and this is something that we've spoken a lot about in our department, if you take these two pieces of legislation, the CARES Act with the Paycheck Protection Program and the Families First Coronavirus Response Act, you've got a 500 employee threshold number in both pieces of legislation. But for many employers, there's a want to be greater than 500 employees for the Families First Coronavirus Response Act in order to avoid having to provide leave requirements, paid leave under that piece of legislation, but then a want to be under 500 employees so as to be eligible for the Paycheck Protection Program. I say that only to state that doing this analysis based on the various frameworks under both pieces of law it's very important, and it's important to actually consult individualized legal counsel on that, to do it on an entity or an organizational basis level.
Great, thank you. Hopefully that answers Eric's question. We did have one other question I apologize I missed during my presentation from Brian Westrate. While viruses are not included, for most, the losses would be due to government closure, not the virus itself. Given that loss from government action and commercial insurance is almost universally excluded, wouldn't that apply? I'm not completely sure the implication on universally excluded. Obviously, some policies do contain civil authority coverage, or in some cases that they may have an additional civil authority, endorsement. What I would say on that is that typically that provision is going to still require that the order from a civil authority, the closure that's prohibiting access, is as a result of or prompted by a covered cause of loss. And so, for example, in the case, the Rising Doe case, the Madison Baker, along with a couple other businesses that has filed in federal court against Society Insurance, their coverage was for any expense caused by action of civil authority that prohibits access to the covered property when a covered cause of loss causes damage to property other than the covered property, and the civil authority prohibits access to the property and its surrounding area and takes such action in response to dangerous physical conditions. So the key piece there was that it has to be a covered cause of loss under their policy. It was covered unless it was otherwise excluded. There was no exclusion for pandemics, and therefore they're arguing in that case that the safer at home order falls under that civil authority provision. So hopefully that answers that question. And with that, I know we are over time here, and I don't think we've got any other questions here. So thank you everyone for your time. I do want to direct you, as we got up on the screen here, Reinhardt has a set of coronavirus resources. We're putting out a number of client alerts really on a daily basis on issues spanning corporate, real estate, tax, labor and employment, and litigation matters. So please take a look at that. I think that there's a link to that on the Chamber website as well. And then finally, next week, we will be hosting another webinar. We will be talking about some tax-related issues as well as some real estate issues related to coronavirus, and following up a little bit on the work you can be doing to clean up your contracts and prepare for possible disruptions in your own supply chain as part of the coronavirus situation. So thank you everyone for joining us. Really appreciate it, and happy to continue our support of the Wisconsin Veterans Chamber. Be well.